And in convening, we come up with what are the essentials of a meeting. One is the proper convening authority. We have talked about directors and in their failure to do so, members. And if we talk about section 132(3) that empowers members not holding not less than 1/10 of the paid up capital. So we need, and this is why it's set out in the Act, that a valid meeting can only be called by proper authority. And if there's no proper authority, no shareholder can assume to have the powers without following the procedures. You see, the shareholders intervene when the directors fail to do their duties. Again, we have talked about proper notice. And it's given to every shareholder. It's given to the auditors, to each director, and any other person entitled to attend the meeting. And when we talk about this, we talked about those who are not shareholders voluntarily, transmission of shares. If there's a succession matter going on, the deceased, so they're not yet granted letters of authority, grants of letters of administration, the deceased person's family should also get notice of these meetings that are going to be held. And the notice must specify the day and the hour of the meeting, and must also contain a statement of the business to be transacted. It can't be blank. You can't call people without telling them, we are meeting probably at 680 Hotel, second floor, on 15th of October at 10 a.m. It needs to be that specific. And what are we meeting to do? We are meeting to review the annual accounts and to pass a resolution on ABCD. So this notice, it must be clear. What we're saying, it must be clear and explicit so that you can decide, is it in your interest to go or it's not in your interest to go? In TSN versus Henderson, Violet, the company was in difficulty and meetings were summoned to put before the shareholders alternative schemes for reconstruction. The scheme which was approved, it was one in which the directors had a strong financial interest, but they never disclosed this fact. The notice merely stated that the guarantors of the new scheme were to have a right of call or share option of 50,000 of new shares of the company, without telling the shareholders that 3 of the directors were interested as such guarantors, and that resolution was invalid. You cannot hide behind vagueness. The matter to be discussed must be clear to all. But in practice, the notice will not go that deep into the details of what will be conducted. And Table A, Article 50, it says that the notice shall specify the place, the day, and the hour, and in case of special business, the general nature of that business. And if it's an AGM, the notice must specify that it's an AGM. And if it's passing a special resolution, the notice must specify the intention or purpose is to pass a special resolution. And this is where we are saying you can decide, is it of interest to you to attend the meeting or not? We talk of method of service of the notice. And this notice can either be given personally or sent by post. And when sent by post, within 72 hours, it's assumed to have reached the beneficiary. Again, we talk of the length of the notice. In Section 133, any provision of a company's article that says you can call for a meeting less than 21 days notice, it's void. by a shorter notice than 21 days, then it's void. And this notice must be in writing. Again, we talk of the articles, but these articles of any company will not be contrary to what is provided for in the Companies Act. So in the case of an AGM, all members are entitled to attend and vote. Any other meeting, then the articles will provide for the quorum. So we talk about the requisite quorum, and this is the specific minimum number of qualified persons, not just anyone, but who is entitled, who has rights, as we talked about, who can come and vote and pass resolutions. And Section 134C provides that unless the articles provide otherwise, quorum for a private company, 2 members present in person, and modified to represent also proxies. Public company, 3 members personally present or by proxy. And we again go to the these exceptions that we talked about, exemptions, the rule whereby a single person is constituted, is deemed to have formed a quorum. We also talk about proper person in the chair, who is chairing, who is presiding over this meeting. And this chairman is responsible for conducting the business. And the committee may have its separate chairman as appointed by the articles. Section 134D provides that unless the articles contain a contrary provision, any member elected by the members present may be a chairman. And those responsible for the convening of the meeting or some other member will nominate a proposed chairman that will be formally seconded. And what are the powers and duties of this chair? 1, it's the duty of the chairman to preserve order, to take care that the proceedings are conducted in a proper manner and the sense of the meeting is properly ascertained. So we talk about the conduct, we talk about the order. If it's a voting session, it should be conducted orderly. And the orders of business are conducted. Why are we having this meeting? If it's to pass a resolution, you as the chairman must ensure that you follow the articles and the provisions of the Act in passing any resolution, be it general or special. So we also talk about the voting. And voting is normally by show of hands or by a poll vote. Unless otherwise, again, we talk of the articles. Common law rule which applies automatically unless expressly excluded. You remember we vote by show of hands, where you're told who agrees by show of hands, the hands are counted, and that's a done deal, you have voted. So we have a poll vote. And this is normally where the show of hands, there's mischief, and a member is unsatisfied with how it went on. A poll is demanded. And any member can demand a poll. And the Act provides that provisions in the articles which make poll votes illegal, they are void. So by voting by poll, each member is entitled to record the number of votes in proportion to the equity shares held by him. This is where you cast a vote according to the number of shares held, and you are allowed to use a proxy. So a proxy is where I can send you to act on my behalf. You're my agent for purposes of that meeting, and you represent my You represent my needs, you represent my desires. And a proxy is also the instrument by which appointment is made. When a notice is sent, it is attached a proxy form, whereby if you're not able to attend the meeting in person, send someone else, appoint someone else to act for you. And Section 136, any member entitled to attend and vote is entitled to appoint another person, whether a member or not, as his proxy. And in a public company, a proxy has the right to attend the meeting for which is appointed or any adjournment thereof.